Ms. Doss warned me that we had to be out of this building by 6 o'clock, and I just cackled. Like, you will not find me in this building at 6 o'clock. However, it is a little bit of a warning that we could be here a little longer than normal. So we ask that if you are commenting, and I'm not just looking at the audience, that we keep our comments succinct and also make sure that we give everyone the proper opportunity to be heard. If you would, in that vein, remember to silence your cell phones and only have water if you're in the courtroom, no other food or beverage. And I would also ask if you have noticed an erroneous date on some of the draft materials that we have here. That is because of the impact of the cancellation from Hurricane Irma. The staff is aware of those dates, and they will be updated in the finalized set of documents. With that, I would ask for a consideration of approval of the minutes from the July 28th meeting.
So moved, Madam Chair.
Is there a second? Any discussion? All those in favor of approval of the minutes, please indicate by saying aye.
Aye.
Any opposed? The motion passes. The minutes are adopted. Our first action for item for action this morning is the consideration of final order regarding complaint number 16198. And before I give too much of an introduction on this matter, I'd like to ask the advocate to give us the current status.
Okay, we were here on the advocate's motion to render a final order. However, at approximately 4:16 yesterday, Mr. Thompson resigned from his position, which renders my motion moot because also the commission loses jurisdiction over him. And at this time, I will ask for, as I would in other cases, I would ask for I'm going to offer order to this motion to dismiss the complaint or the case because the commission no longer has jurisdiction over him.
Thank you, Ms. Adley. Therefore, ask for consideration of a motion to dismiss this matter.
So moved.
Second?
Second.
Any discussion? All those in favor of the motion, please indicate by saying aye.
Aye.
Any opposed? The motion passes. We'll now move to consideration of final petition for cost and fees. We're going to skip the consideration of final action, cost and fees regarding Mr. Hadid. That matter has been continued. So if you'll catch up on complaint numbers 16-023 and 16-031, which have been consolidated regarding Mr. John Drew. The attorney's fees case filed by Mr. Drew, who's the respondent in this matter, seeks to have the complainant, Mr. Carlos Slay, pay attorney's fees and cost following the dismissal of the complaint against Mr. Drew. Are either Mr. Drew or Mr. Slay present? Would you please introduce yourselves?
Carlos Slay. I'm Leonard Collins. I'm counsel for Mr. Slay.
Thank you, Mr. Collins.
Louis Baptiste with Halo Scarpone on behalf of Honorable Tax Collector John Drew.
However, Honorable John Drew is not in attendance today, so we are here on his behalf.
Thank you. Thank you for your attendance. We have copies of the file in this matter and the staff's recommendation that we find the petition sufficient. I think that we just have some extra documents passed around. This is because counsel for Mr. Slay filed a motion to dismiss the petition. And if you haven't had a chance to read it over, I'd ask you to do so very briefly now and give me a nod when you've completed that. take about another minute to wrap up your review. Commissioners, if this motion is granted, the proceeding is over. If it is denied, both parties will be heard on the question of the sufficiency of the petition. If any member wishes to hear any oral argument just on this motion, let me know. Does anybody want to hear oral argument just on that procedural motion? Okay. Hearing none, I think that your petition was, or motion was fully developed in writing, and the commissioners have had an opportunity to read it. At this time, I'd ask for one commissioner to consider a motion on whether to grant or deny the motion to dismiss.
I'll move to the motion.
You'll do what to the motion? I'm sorry.
The motion you requested, which is to deny the petition to dismiss.
Okay, so if I heard you correctly, please correct me if I'm wrong, because I'm not sure if I did. Your motion is to deny the motion to dismiss.
Yes.
Second.
Any discussion on the motion to deny the motion to dismiss? Hearing none, all those in favor of the motion to deny the motion to dismiss, please indicate by saying aye.
Aye.
Any opposed? Okay. So with that, we are now on to the question of the sufficiency of the petition. If the petition is deemed sufficient, the matter will be sent to the Department of Administrative Hearings for hearing. If it is found insufficient, the case will be dismissed. So thanks for sticking with us as we make our way through. At this time, I will ask Mr. Gray Schaefer to help us to continue to make our way through. But I'd ask the commission to remember, and as well as all of the council involved, that Mr. Schaefer's role here is to provide counsel to the commission, which is Mr. Gray's client here, and not to engage in debate with any of the other attorneys. So we do not place him in this role in an adversarial position. Mr. Schaefer.
Thank you, Madam Chair. Commissioners, as you heard, this item concerns a petition for fees and costs brought by John Drew, the Nassau County tax collector. He was the respondent in complaint numbers 16-23 and 16-31. His petition has been filed against Mr. Carlos Slay, who was the complainant in both of those matters. I reviewed the petition. My recommendation is that you find it to be facially sufficient, and that simply means that if you accept its allegations as true, looking just at the four corners of the petition, that it sufficiently pleads each of the elements that are required to establish a claim for costs and fees under Section 112.317, subsection 7, which is the fees and costs statute in the Ethics Code. And there are three elements cited in that statute I just want to review with you. First, that the complaint was brought with a malicious intent to injure the public officer's reputation. Second, the person filed the complaint knowing it contained one or more false allegations or acted with a reckless disregard as to whether it contained one or more false allegations. And third, the false allegations are material to a violation of the code. Again, my recommendation is that the petition does allege each of these elements and makes factual assertions to support its claims. So because of that, my recommendation, again, is to find the petition to be facially sufficient and refer it to DOA, where it will be assigned to an ALJ for a fact-finding hearing. My understanding is that both parties are here today and are prepared to address you, but I'd like to remind you this is simply the initial sufficiency stage of the fees proceeding. This is not an evidentiary hearing. So it would be premature to hear arguments about the merits of the petition or whether the amount of fees and costs cited in the petition is reasonable. Those are factual issues that will need to be resolved if the matter is referred to DOA. My recommendation, again, is to find the petition is facially sufficient, that it addresses those elements, and to refer it to DOA.
Thank Thank you, Mr. Schaefer. Any questions of Mr. Schaefer before we move forward? In that case, I would ask whether Ms. Scarpone or Mr. Baptiste, do you have any initial comments you'd like to make? And if so, I'd ask you to come to the podium and limit your remarks to 15 minutes.
Good morning, Commissioners. My name is Kayla Scarpone. I'm here on behalf of the Honorable John Drew, the respondent in the underlying ethics matter, and on our petition for costs and attorney's fees. I thank you all for your time today and undertaking the time to consider the sufficiency of our petition. I will not belabor the point and take up too much time. We stand on our petition as filed. We believe that we've sufficiently alleged facially all the required elements, and that is enough to get us to DOA, and that we are entitled to undertake a formal hearing there under the procedures in Chapter 120 in the Florida Administrative Code. That would include full discovery on this matter to fully litigate the merits. I do understand that I'm sure Mr. Slay denies the allegations in our complaint, may have alleged and assert defenses to those, but this is not the place to address that. That should be addressed at DOA. Again, we stand on our complaint. We've sufficiently alleged all of the elements, including the complainant's malicious intent to injure the respondent's reputation by making the complaints based on the case law cited in our petition, timing and tenor, and the fact that he was a political opponent is all relevant to that consideration. Also specifically pointed to statements and allegations in the complaint that we, upon information and belief, allege were made either in a knowingly false manner or with reckless disregard for the truth, and that those statements were material to a violation of the ethics code, as demonstrated by the fact that the complainant's complaints got past the legal sufficiency stage and were ordered to be investigated. And we have alleged that the Honorable John Drew has incurred attorney's fees to date in defending that complaint and getting it dismissed with a finding of no probable cause. So again, we stand on our petition. We believe it's sufficiently alleged, and that you should refer this to the formal hearing at DOA. Thank you.
We reserve all remaining time to respond if permitted.
Thank you.
Thank you.
Any questions for Ms. Scarpone or Mr. Baptiste before they step away? If not, you may
Thank you.
come back later for your rebuttal. Thank you. Mr. Collins.
Morning.
Morning.
I'm Leonard Collins. I represent Mr. Carlos Slay, who is the complainant in this case. We've moved, we're considering the legal sufficiency of the complaint of the motion for fees and costs. In order for this commission to determine whether the document before you is sufficient, I would ask that you be able to identify specifically the statements that Mr. Slay is alleged to have made that are false. What is before you is a document that says that Mr. Slay made a complaint and that the commission found no probable cause. I would argue that that is not the standard by which you should be analyzing complaints to determine if they're sufficient to go to DOA. Here, there are a host of statements that Mr. Slay is said to have made. It is unclear in the document as to whether or not those statements were in his complaints. Mr. Slay submitted 6 different documents to the Commission on Ethics. Your inquiry is limited to those documents only. So if Mr. Slay made a statement in public and that statement was false, it would not be actionable unless that same statement was in his complaint. And so limiting ourselves just to the complaint it is absolutely unclear as to what specific statements he is alleged to have made that are false. And so I would ask the commission and I would ask counsel, because you just heard from counsel and they said there was a complaint that was made and there was no probable cause found. Not one statement that Mr. Slay made in his complaint that is alleged to be false was stated. I would ask, what statements specifically are they referring to so that we can defend ourselves against this complaint at DOA? That's it. I mean, that is the crux of the argument in terms of legal sufficiency. The complaint must state what statements, I'm sorry, the petition must state what statements were false. And you don't have to rule on whether they were false or not, but you have to know what they were. Otherwise, it's completely amorphous, conclusory, and then anyone who files a complaint with this commission is subject to going to DOA, incurring attorney's fees, and dealing with the entire DOA process without knowing what specifically they are alleged to have stated that somehow is claimed to be false. We don't know that as of now. And I would ask counsel, I'm going to reserve my time, I've only spoken for a couple of minutes. I would ask counsel, they've got a lot of time, what did my client say that you are acting on? And I would ask the commission the same question, what did he say? And if you can articulate that, then a complaint has been made and we can go to DOA and address it. If you cannot articulate that, then I would ask that you find it's not legally sufficient. Thank you.
Before you step away, Mr. Collins, any questions from the commission? Mr. Collins, may I just ask you, in your initial remarks, you suggested that there was a standard by which we review this. What is your description of that standard?
The standard is that there is a specific statement, that statement was made with malicious intent, that statement was false, and that statement was material. And the materiality piece is, in my view, in this case, the most important piece, because Mr. Slay is alleged to have said things in newspaper articles. Mr. Slay is alleged to have said things in other public forums. And all of those things, even if you found that they were false, even if you found that they were outrageous, this commission doesn't have jurisdiction to send those things to DOA. The only thing this commission should be looking at is what was in those 6 documents that were filed with the commission that ultimately allowed the commission to conduct its investigation. And so the standard is, within the 6 documents that were filed, no oral statements, no newspaper statements, within the 6 complaints, what specific statements were alleged, just alleged, to be false? Thank you.
Mr. Collins. Mr. Baptiste.
I again want to thank you for your time. Louis Baptiste on behalf of the Honorable Tax Collector John Drew. I first want to start off by addressing opposing counsel's arguments. The standard he stated is not identified in law. There's no case citation for it. When a complaint is filed, Mr. Slay's complaint contained 273 pages. So it wasn't just 6 allegations. In fact, if you review the complaint that was filed, Mr. Slay filed several attachments, newspaper articles. He filed those attachments so that the commission could review those attachments. The way that civil procedure works and that we're taught in law at the foundation is that if you file an attachment with a complaint, it's so they can be considered with the complaint. The two become married. So essentially, Mr. Slay's newspaper articles, everything he filed to the commission for its review became married to his complaint and essentially part of his complaint. So to argue that we're limited to those 6 things or the 4 corners of just that document, we're limited to the 4 corners of everything he filed, his complaint. Those 273 pages are included, and that's supported by Twombly-Iqbal, the foundations of civil procedure and notice. Additionally, to address the specific comments that were made, counsel asked a question. He asked me to come up here and answer what specific comment he made, Mr. Slay, that was false. I'll answer the question. Mr. Slay stated that 2 boats on the property belonged to John Drew and that he was misusing his position as a tax collector to store those boats. The commission investigator found out that those boats, in fact, belonged to FWC, One of the boats had FWC markings on it. The pictures Mr. Slay filed with this commission were obscured and were taken in a manner as to not show the FWC insignia on this boat. He nonetheless told this commission in his report that can be found that those boats belong to the Honorable John Drew. That's objectively false. There's no subjectivity to it. There's no argument that can be made. Either the boats belong to Mr. Drew or they belong to the State of Florida Fish and Wildlife Commission. It's been found, it's clear, those boats belong to the Fish and Wildlife Commission. Furthermore, Mr. Slay alleged that our client, Honorable John Drew, used his official position to give his wife a job. There was no information found by the investigator to support any allegation whatsoever that John Drew used his position to get his wife a job. Furthermore, in the attachments filed with the complaint, Mr. Slay alleged that John Drew threatened to withhold tax funds to the school district if his wife wasn't given preferential treatment. First of all, the Honorable John Drew has a constitutional duty to disperse tax funds. That's his job. So when Mr. Slay made an allegation in that complaint through that attachment, which, as I stated earlier, becomes married to that, he alleged that my client would perform his constitutional duty in disperse of tax funds. In closing, I'd opine to the Honorable Commission that we're not here to debate facts. We're not here to argue whether or not the camper really belonged to John Drew, whether or not the boats were really there, excuse me, whether or not his wife was really withheld the position. That's not why we're here. That's not the purpose of this hearing. As your general counsel stated, this hearing is to determine if the statements in our petition are found to be false, are found to be true, would that be material and would that be a violation? Well, as my co-counsel argued in the beginning, by the fact that the commission recommended those items be investigated, that's automatically saying that if they had been true, they would have been a material violation of the Ethics Commission. If we don't assume that, then that means that it would have been dismissed and never been ordered to be investigated. But because it was investigated, that means if those things were true, then they would have been problematic. But an investigation was done, a very fine investigation, might I state, and it found those things weren't true, which is why we're here. We'd asked that we be referred to DOA, and if Mr. Drew and his counsel want to do discovery and want to walk through the process, we're ready to walk through the process. But as for this matter, in here, the petition is legally sufficient, and I'd ask that you find that. Thank you for your time.
Thank you. Any questions for counsel for Mr. Drew? Thank you. At this time, I would ask the commission consider a motion on whether or not the petition is sufficient, and if so, it will be referred to DOA, and this is the appropriate time to have that motion.
I have a comment. So I'm struggling a little bit here and asking maybe my fellow commissioners to help me out here with this, because when I read the fee petition, in some of the opening statements, it seems to me to be pretty apparent that the fact that Mr. Slay ran against Mr. Drew seems to be a motivating factor as to why they're filing this fee petition. And I have a concern that, that's sort of a fine line there when you run for political office, like it or not, about anything goes. And to me, it sort of smells of this is a retaliation by Mr. Drew for Mr. Slay running against him. And I'm a little bit uncomfortable in referring this for that matter. So maybe somebody can give me some enlightening on that. Or maybe I'm the only one seeing it.
If not, I'd like to ask, go ahead, Commissioner Berger, and if not, I'm going to ask Mr. Schaefer if you have a response.
Just from my perspective as one commissioner, we're looking at the legal sufficiency. We're not the ultimate fact finder of this dispute. And from one on a panel, having read both sides, heard both sides, my opinion is there's probable cause. Where this goes in the hearing, we'll see. But if the mandate is to look at the legal sufficiency based on the facts presented and argued in the petition and the response. That's one of 7 here today.
Anyone else want to respond to that particular question? Mr. Gray, Mr. Schaefer, do you have any particular remarks you do not?
Well, I would just echo what Commissioner Berger just said. Regardless of the motivation for the petition, the analysis today is whether or not the elements of Section 112.317 subsection 7 have been fully alleged in the petition. It's a very narrow legal issue. So I would just emphasize that what we're looking at here is just the provisions in that statute.
And for better or worse, it's not only narrow, it's really rather superficial at this stage, meaning that the evidentiary part is where I think the deeper analysis comes from, and unfortunately, we're not charged with that level of analysis.
Well, let me just make another comment. Mr. Drew's attorneys stated that the fact that a newspaper article was attached to the complaint, that was inappropriate to do that. But this commission has heard cases that was the only thing attached to the complaint. I mean, the complaint was filled out, it was signed by the complainant, and the narrative that normally follows by the complainant as to why they think someone has violated an ethics law, the only thing that was there was a newspaper article. And the executive director has issued an order to investigate, and this commission have heard those cases. So if something's out there in the newspaper and a reporter has done written an article on it, and the citizen believes that, hey, that's not right, somebody needs to file a complaint, and they do it, I think it's wrong that then, if it's found no probable cause, that complainant then is hauled off to DOA to try to get fees reimbursed. I think that is sort of counterproductive to people filing complaints.
Which is why
So-
I think you should run for the legislature.
Well, I don't know. I think that we ought to hold these types of requests at a higher standard, because if we don't, this is just my personal opinion, that it would disencourage people from filing complaints that should be filed. So I don't think I'm going to support this.
Thank you, Commissioner Cox. Any other comments? If not, I would entertain a motion on the sufficiency of the petition.
I move that we determine the petition is legally sufficient and submit this to DOA.
It's been moved and seconded that the petition is legally sufficient. Is there any discussion? Taking into consideration, I think Mr. Cox would ditto his comments. Hearing none, all those in favor of the motion, please indicate by saying aye.
Aye.
Any opposed?
Aye.
The motion passes and the petition is found legally sufficient. Thank you for the fine advocacy. I'm going to state my age and say that I'm now looking at you as young lawyers, and it's particularly encouraging to see such good work. Thank you. I'm not as old as some people that are lawyers on this commission. At this time, we'll consider complaint number 16-042 regarding Yvette Weeks. Is anybody here on behalf of either the complainant or the respondent in this matter? Seeing no one here on their behalf, I would ask Betsy Daly to please make a report.
Thank you, Madam Chair. In this case, an attorney representing a community development district is seeking on behalf of the district reimbursement of attorney's fees incurred by a district board member who was named in an ethics complaint in 2016.
Ms. Daly, if I can interrupt, I think there's a commissioner prepared to make a motion on this matter.
Oh, sure.
I move that we dismiss this petition and accept the order prepared by staff.
Second.
Any discussion on the motion to have the petition dismissed? Hearing none, all those in favor of the motion, please indicate by saying aye.
Aye.
All opposed? The motion passes. Thank you, Ms. Daly, anyway, for being prepared to speak to this. This time, we'll move on to consideration of final action in the joint stipulation regarding Danny Coolidge. Apologies for that. the parties or their counsel present?
Melody
Please
Hatley.
introduce yourself, sir.
Yes, Dr. Rick Betcher.
Thank you for being here. Ms. Hadley?
Melody Hatley, Commission Advocate.
Oh, Mark,
Aaron on behalf of Danny College.
thank you all for being here. We have before us a proposed pre-probable cause stipulation between the commission advocate and the respondent. After considering all the materials and the presentations of the parties, the commission may vote to approve or reject the stipulation. As you know, if the stipulation is rejected, we go immediately into a probable cause hearing, and the complainants have the right to comment in writing on the proposed stipulations. We did receive a comment on this particular matter on October 18th, and it was emailed to you that day. Does anyone else need a copy of that, hard copy? Hearing none, at this time I'd ask Ms. Hadley to make your presentation.
At this time, I bring before you a pre-probable cause stipulation. Respondent acknowledged that he failed to accurately file CE Form 6s from 2012 through 2015 respectively in violation of Article 2, Section 8 Florida Constitution and Section 112.3144. Although a violation of the financial disclosure provision for respondent's 2014 CE Form 6 was not alleged in the ethics complaint, respondent agreed to the inclusion of that form as a part of the resolution of that complaint. His filing of the CE Form 6Xs in these cases led to an easier analysis of the issues. We ask the Commission to accept respondent's stipulation that he violated Article 2, Section 8, Florida Constitution, and Section 112.3144, and recommend a total civil penalty of $5,000.
Thank you, Ms. Hadley. Mr. Herron, any comments?
Mark Herron on behalf of Danny College. We would urge the commission to adopt the joint stipulation and would note that in the submission by the complainant, he likewise hopes that the commission will accept the joint stipulation and penalty recommended. Thank you.
Thank you, Mr. Herron. Thank you, Ms. Hadley. Any questions for counsel?
I have a question for Ms. Hadley. How does this fine compare, and mainly this is, I think, for the benefit of the complainant, who did a very good job in laying out a lot of these financial assets. As a financial planner, I appreciated the detail in which that was given. But how does this $5,000 fine compare to other cases and historically cases that have gone through the whole process and ultimately come back here for a determination of a fine?
With this particular case, we ask that you take into account that it is a pre-probable cause stipulation. With pre-probable cause stipulations, due to the fact that the respondent is acknowledging a violation, we didn't have to do additional discovery, especially in this case with the respondent filing those 6Xs. We didn't have to hire forensic analysis nor get request different discovery and have to go through an analysis of all the different assets, liabilities, income. So based on those issues, as a matter of fact, this might be a bit higher than I would have normally asked.
Okay, that's what I was trying to get at.
Thank you. Any other questions for counsel? If not, I would entertain a motion regarding the joint stipulation.
Move for approval.
Second.
Any discussion? All those in favor of approval of the joint stipulation, please indicate by saying aye.
Aye.
Any opposed? The motion is approved and the joint stipulation is adopted. Thank you. Mr. Betcher, and if you'll convey to your client, Mr. Herron, we give our best to those recovering in the keys, and thank you for making this venture up here during these kind of difficult days.
I think you got 3 more of them.
Yeah, we
I
have 3
do.
more, yes.
I almost said it at the beginning for everyone here from any hurricane-damaged area, so I'll just say it now, though. You've endured a lot. We're proud, stand with you, and continue to rebuild. We'll come visit.
Alternating power washing my back with filing my response.
Extra points. Thank you. At this time, we'll move to complaint number 17-023 regarding Heather Carruthers. Anyone present on behalf of the parties? Again, Mr. Betcher, again, Mr. Herron. Ms. Hadley, would you please make your remarks?
At this time, I bring before you a pre-probable cause stipulation. The respondent acknowledged that she failed to accurately filed CE Form 6s from 2012 through 2015. Again, her filing of the CE Form 6Xs led to an easier analysis of the issues, and we asked the commission to accept the respondent stipulation of a violation, and we recommend a total penalty of $5,000.
Mr. Herron.
I would have just said same as before, but with respect to Heather Carruthers' financial disclosure statement, the issues involved in completing that statement were significant because of the transaction that involved the sale of her hotel down in Key West and the way that the payments were made over time. As Ms. Hadley noted, you guys didn't have to hire the forensic accountant to figure it out. I did. And it was quite an adventure trying to figure out how to allocate the income, notwithstanding the instructions that are on your form. I know that I met with staff on a couple of occasions trying to figure out how to report the income. And so, and had to do with accountants on how to read these income tax statements to figure out where the income was over the years. So again, the complainant again indicates that he is satisfied with the penalty and the joint stipulation and would urge you to adopt it.
Thank you. Any questions for council?
I have one quick thing. I guess I'll ask the question once because it's for four similarly situated cases. The recommendations made and the agreements reached, they are substantially similar to cases that have been similar and have been brought before this body before in the past, present.
Well, actually, this is probably not similar to what we've had before. I don't know if what I've had before where someone did a 6X that thoroughly and provided assistance in figuring out what was wrong with the original document. So there again, there was quite a bit wrong, but we really know it because this person filed a 6X. So based on what happened, and also there were some incorrect inaccuracies. However, taking into account the inaccuracies and taking into account what the respondent did to fix those, I think this is a valid fine.
Any other questions for council?
Move for approval.
Second.
It's been moved for approval and seconded to adopt the joint stipulation. Any discussion? All those in favor of the motion, please indicate by saying aye.
Aye.
Any opposed? The motion passes. Thank you. We'll move also on to the complaint numbers. Oh, I'm so sorry.
No, I was going to say, David Rice is an old acquaintance of mine. I worked with him extensively in the 80s and 90s when he was the director of the Mental Health Center in Islamorada, and am recusing myself from any discussion.
I'm sure the staff will coordinate with Mr. Brady to ensure that we documented that properly. Would you like to address that, Mr. Anderson?
If I might, thank you. I don't believe that's the sort of relationship that would require the filing of a form. That's a past relationship where you work with the person. Is that right? There's no current economic relationship with them or anything like that? I appreciate him announcing it, but I don't think we'll need to do a form on that one.
Thank you, Mr. Anderson, and thank you for that disclosure. Again, we're on complaint number 17-024. I think we still have the same cast of participants. We recognize you, Ms. Hadley.
Thank you. Again, bring before you a pre-probable cause stipulation. The respondent acknowledged that he failed to accurately file CE Form 6s from 2012 through 2015. Again, his Form 6Xs led to an easier analysis of the issues, and we asked the commission to accept the respondent's stipulation that he violated the Article 2, Section 8 Florida Constitution and Section 112.3144 and recommend a civil penalty of $6,000.
Thank you, Mr. Herron.
On this one, I'm standing in for Mr. Horowitz and Mr. Gorin, who represented Mr. Rice below, but again, consistent with other presentations, we urge you to adopt the recommendation.
Thank you. Mr. Zanka.
Why is this one higher?
Because I thought that the inaccuracies were more egregious.
I'll make the motion.
Commissioner Berger's moved the approval of the joint stipulation. Is there a second? Any discussion? All those in favor of the motion, please indicate by saying aye.
Aye.
Any opposed? The motion passes. Thank you. And if you want to stay close, we are at complaint number 17-025 regarding Sylvia Jean Murphy. We have the same participants on behalf of the complainant and the respondent, Ms. Hadley.
Okay, at this time, I bring before you a pre-probable cause stipulation. The respondent acknowledged that she failed to accurately file CE Form 6Xs from 2012 through 2014. Her filing of the 6Xs, and let me rephrase. Respondent acknowledged that she failed to accurately file CE Form 6s from 2012 through 2015. Her filing of CE Form 6Xs led to a easier analysis of the issues, and we ask the Commission to accept respondent's stipulation that she is in violation of Article 2, Section 8, Florida Constitution, and Section 112.3144, and recommend a total civil penalty of $4,000.
Thank you. Mr. Herron.
Same presentation as before, and Ms. Hadley will tell you that the amount here is lower because she didn't view these as egregious as the others.
Correct.
Reading our minds, thanks for the advanced answer. Any other questions for council?
Make the motion.
Commissioner Berger moves the approval, seconded by Commissioner Norris. All those, any discussion? Hearing none, all those in favor of the motion indicate by saying aye.
Aye.
Any opposed? The motion passes. Thank you, both of you and all of you, for your participation in those four matters, and again, your efforts to be here today, Mr. Betcher. At this time, we'll move on to the consideration of the final advisory opinions. We have four up today. The first one will be file 2696. It will be presented by Mr. Gray Schaefer. There is an additional response that was received from the requester on October 12th, which you were emailed last week, but does anyone need a hard copy of that document?
Madam Chairman, I have 6. Have 2 been continued?
1, 2, 3, 4, 5, 6. Yes.
Thank you.
There are 6. Thank you, Ms. Rosenka. That's okay. 6 looks like 4 in writing.
I think it was 4 last
Is
month.
the requester here for the first conflict of interest voting conflict regarding the city commissioner serving as a charter school attorney while the city sells or transfers property to a charter school? He's here. Would you announce your name for the record, sir? Thank you, Mr. Gibson, and thank you for your follow-up writings. Interesting to read. But at this time, I'll ask Mr. Schaefer to make a presentation on this opinion.
Thank you, Madam Chair. Commissioners, this is a somewhat complicated opinion, so I would just ask for your patience as we work through it here. It involves a Lake Wales City Commissioner, Mr. Gibson, who serves as an independent contractor as the general counsel for a local charter school system. The charter school would like to purchase some property from the city to build a new middle school. The commissioner called our office wondering if he had any type of conflict if the city commission were to transfer title of that property to the charter school, considering that in his private capacity serving as a charter school's attorney. The first statute to consider here is section 112.313, subsection 7A. The first part of that statute prohibits a public officer from having an employment or a contract with any business entity or any agency doing business with his own agency. And if you look at question 1 of the draft opinion, the recommendation there is that the commissioner will have a prohibited conflict under the first part of the statute if the city commission decides to transfer title to the charter school for consideration. So in other words, he'll have a conflict under the first part of the statute if the city commission wants the charter school to pay for the property. And that's because he'll be smack dab in the middle of this whole transaction. He'll be in contract with an entity, the charter school, doing business with his agency, the city commission, and that'll trigger the first part of the statute. Now, much of my correspondence with the commissioner is concerned whether the charter school should be considered a public agency or a private business entity. But I want to emphasize, if the property is being sold for consideration, that distinction won't matter. He'll have a conflict either way because the statute applies when an individual has a contractual relationship with either an agency or a business entity doing business with his own agency. So if this is a property sale, question 1 recommends you find that there will be a conflict. Now, the commissioner has also indicated it's possible the city could decide to transfer title to the charter school through a quitclaim deed and not ask for any consideration. So that would be akin to the city donating the property to the charter school free of charge. Now, question 2 addresses that scenario. Now, again, the first part of subsection 7A requires a public officer to be in contract with a business entity or an agency doing business with his own agency. Now, the doing business prong is something to focus in on here. You all found that doing business requires an exchange of consideration. So a donation of property, you have found in the past, will not suffice as doing business. So if the title transfer is made without consideration, if the property is donated, it doesn't look like the first part of the statute will be triggered because you won't have an agency or a business entity doing business with the city commission. Now, that's the first part of the statute under this donation scenario. But we've got to look at the second part of the statute then, move on to that. Now, the second part of 112.313 subsection 7A applies if a public officer has an employment or a contractual relationship that could impede the full and faithful discharge of his public duties. And like I said, as it stands now, the city commissioner here is smack dab in the middle of this transfer issue, even if it's done as a donation, because he is on the board of the city commissioners that has title of the property, and he's employed by the entity, the charter school, that wants to get title of the property. Now, the commissioner relates that neither he nor his law firm will be handling the representation of the charter school on this title transfer issue. He's indicated they're going to recommend that the charter school hire a transactional lawyer to handle the title transfer. So if that's the case, if he removes himself from representing the charter school on this issue, and if he refrains from attempting to act in favor of the transfer in either his private or his public capacity, it doesn't appear his contractual relationship with the charter school will impede his ability to perform his duties as a city commissioner. But there's got to be those limitations. It's got to be done as a donation, and he has to have no involvement with this transfer in either his public or private capacity. Assuming that's the case, question 2 recommends finding a second part of the statute won't apply. That leaves one last issue, which is whether he'll have a voting conflict if he votes as a city commissioner to transfer title to the land of the charter school. And that's addressed in question 3 of the draft. And the voting conflict statute, which is section 112.3143, that's going to prohibit a local officer like the commissioner from voting on any measure that will bring special private gain or loss to a principal who retains him. And special private gain or loss just means some type of financial effect, economic benefit or harm. Now, here the charter school retains the commissioner. It's his principal. So it seems he'll have a voting conflict for any measure dealing with this title transfer, because the charter school's finances are going to be affected if it acquires this extra parcel of property, because property inherently has value. So question 3 recommends that you find a voting conflict if he votes in these types of issues. Now, question 3 goes on to address a narrow exception in the statute, which is that a public officer can vote on a measure affecting his principal, even if it will have a financial effect, if his principal is an agency under section 112.312, subsection 2. The commissioner here argues that charter schools should be considered a governmental agency, and therefore he should be allowed to vote on measures affecting it. And he supports that by citing language in the K-12 Education Code that says that charter schools should be considered public schools. That's found in section 1002.33, subsection 1. And the quote there is just a general phrase. It says all charter schools in Florida are public schools. And he also emphasizes a separate provision in the Education Code that indicates that charter schools are subject to the same sovereign immunity statute that applies to certain state agencies. Now, those are valid points, but the opinion in question 3 still recommends that you not treat charter schools as public agencies and apply that exception to the voting conflict statute. And there are a couple of reasons why. First, to do so ignores the corporate nature of charter schools. This charter school here is organized according to an Articles of Incorporation. It's not subject to control of a public office or a public body, it's subject to control of a private board of trustees. So because of that, I'm recommending that it seems to have more in common with a business entity than with a public agency, like a public school. And notwithstanding that language that states charter schools should be treated as public schools, that's not how the legislature has acted in the rest of the statutory scheme. The scheme that sets up charter schools exempts them from most of the provisions of the K-12 Education Code that are applicable to public schools. And unlike public schools and all public agencies, charter schools are exempt by statute from the bulk of the Code of Ethics. And while they are subject to that sovereign immunity statute, that statute sets out a very specific definition of who's going to fall under its language. And it restricts that definition to just apply to that particular statute. So the definition of a state agency for the purpose of the sovereign immunity statute is not going to have any meaning outside other contexts, like in the Code of Ethics. And I'd add to that that the sovereign immunity statute, you all found that while it applies to certain private corporations, like Pride, the prison entity, the Private Prisoners Corporation, you all found the Ethics Commission still has no jurisdiction over Pride. So just because an entity is treated as a public agency for the purposes of the sovereign immunity statute, that doesn't mean that it's a public agency for the purposes of the Code of Ethics. So basically, the opinion recommends finding the charter school here should not be treated as a public agency based on its corporate nature, and the fact that besides that isolated comment and the education code, the legislature has not treated charter schools as public agencies either. So without that agency exception applying, the opinion recommends finding a city commissioner here will have a conflict if he votes on any issue that would transfer title to this charter, concerning this title transfer to the charter school. I appreciate your attention. I know this has been a long summary. I offer it for your review. I'm happy to answer your questions, and I know that Mr. Gibson would like to address you as well.
Thank you, Mr. Schaefer. Any questions for Mr. Schaefer at this time? Hearing none, Mr. Gibson, we invite you to the podium. I don't think you'll need 15 minutes, but you're limited to that, please.
I won't take the 15 minutes. I think when we started, the word was succinct. Good morning. I am Robin Gibson. I'm a lawyer from Lake Wales. What I've done is written something out. It takes 3 minutes and 37 seconds. So if you don't mind, I'll do that.
Please take your time.
Okay. And I think you have my response. We're in most agreement. The only disagreement I have is conflict of interest. So that's what this is about. The reason I believe I'm eligible to participate in the discussion and vote is because, in my view, there is no conflict. The statute requires that I or my principal, which is my client, the charter system, experience, quote, a special private gain or loss. That makes sense. No one should pocket any money because of a decision he or she made in public office. As for me, it's acknowledged that I personally have nothing to gain or lose regardless of what happens. The issue is my principal, the Lake Wales Charter Schools, Inc. The draft opinion says that it is, quote, similar to, quote, a private corporation and thus will experience the required special private gain or loss. That's just simply not the case. The school's articles of incorporation state that the entity, quote, has not been formed for profit or financial gain, close quote. The IRS has certified that the entity is a not-for-profit corporation with a 501c3 status. The entity provides local management of the same public schools as before. We just took over the schools that were public schools. The community decided that it wanted local management of its schools rather than off in Bartow. Polk County is as big as the state of Delaware, and we have done well with our locally managed schools. The entity does not issue stock, and there are no shareholders. There is no private ownership of any kind. Its trustees serve without pay as a community service. Its structure is the same as the city's municipal corporation. The mere fact that it's a corporation does not mean that it is a private entity. The city's municipal corporation is a public entity with no stockholders operating pursuant to a charter issued by another public entity, the state of Florida. Thus, my principal, Lake Wales Charter Schools, Inc., is structurally incapable of experiencing a private gain or loss. The key word is private. There is not a bit of private interest involved in this endeavor. The facts demonstrate that neither I, this is the statutory language, any of my relatives, a business association, nor my principal, the charter system, has received or will receive the special private gain or loss required by the statute for a voting conflict to exist. Lake Wales is proud of the fact that its public schools are measurably better, and the exodus of Lake Wales students to out-of-town schools has been reversed. And now the Lake Wales schools have waiting lists. I had a lot to do with organizing the community-wide effort that made it happen. And to maintain that either I or anyone associated with my principal were in it for private gain cheapens the whole effort. The schools now have to service a 400-student waiting list. Renovating the town's historic school complex that was originally abandoned by the school board and donated to the city is a possible location. The question as to whether the city should donate or sell the historic school complex to the schools is a policy question. It's not an ethical one. There may be a conflict of opinion, but there's not a conflict of interest, as that term is defined in Florida law. Part of why I received a majority vote over two opponents, by the way, it's the first time I've ever run for public office, it was the nuttiest thing I ever did.
I understand.
Part of why I received a majority vote over two opponents, including the incumbent, was so the schools and the city could work closer together for common benefit. Great schools make strong communities. I am biased in favor of public schools. I concede that. The voters have expressed themselves, and they are entitled to have their wishes heard. I'd be glad to stand for questions.
Commissioner Rosenka.
I'm hoping I'm going to get this question correct. If the land is donated and the corporation goes out of business, what happens to the land?
My question.
The corporation goes out of business. You're talking about the charter schools.
Yes,
It goes to the school board.
that's what I thought.
There's a statute that says that if you go out of business, and every pencil, sharpener, every desk, every building, they're all public.
That's what I thought. Thank you.
Someone smarter than me asked to inquire whether or not that is the law, or is that unique to the corporate governing documents?
It's in the statutory law. There's a whole section on charter schools, 1002.33.
Thank you, Mr. Gibson. Commissioner Brady.
Yeah, as a person who spent their life working in private nonprofit corporations, you need to take my word for it that there is profit and loss. And the real issue there becomes how you dispose of those assets at the discontinuation of the corporation. And someone who understands that for people that are not actively involved in the nonprofit world, there gets to be a sense that they can't make or lose money, which nonprofit corporations make and lose money all the time, and the real issue gets to be the disposition of assets. My suggestion to you, particularly if you have the votes, to donate the school to what appears to be a wonderful charter school company is simply to abstain and wish them the best of luck as they move forward.
And if, actually,
That's free advice, Mr. Gibson.
that's, yeah.
From a non-lawyer.
Yeah. I've given a lot of free advice in my term, too. And I may very well wind up doing that. But actually, if there's an undertow that I have received or the people I work for have received any private gain, I want to do away with it. And because anybody who contends that there is a conflict of interest, and they pick up that statute and say, because of special private gain or loss, then that in a way is saying either I or somebody I'm associated with is pocketing money. It goes on to say it has to be an economic benefit. And I think that was a good question. It goes back to the public.
Commissioner Cox.
Were you working for the charter school before you became a city commissioner?
Yes. Listen, I'll tell you what the deal was. I've been active in education issues for a long. I chaired the Board of Regents. My community, the schools were in decline. And so I got involved, and there was a way in the statutes where you could convert our schools, our public schools. They remain public schools. And one of the problems we have is people think charter schools are private schools. People in Lake Wales think charter schools are private schools. So I got involved. The statute said that you could have charter schools reporting to one board. So then we could form what was basically a community school system, like in the Northeast. That's basically what we've done. I chaired the steering committee beforehand. I chaired the board of trustees. I wrote the bylaws. It says after 2 terms, you've got to leave. I left. I've remained as the lawyer. I work for a discounted rate that pays my overhead only. This is an effort that is we're all proud of, and I personally don't like the undertow that anybody would profit from it individually.
Any other questions for Mr. Gibson? Hearing none, thank you, Mr. Gibson.
Thank you.
For your presentation. At this time, I would ask the commission to consider a motion on this advisory opinion.
Question.
I'm sorry, Commissioner Norris, can I put you on pause just because I think Mr. Anderson might have some guidance?
If I might, and I'm not adversarial, this is not adversarial at all, but in order, to advise the commission as counsel, I feel like I need to weigh in on a couple of points that Mr. Gibson brought up. If you just indulge me just briefly. First of all, the code of ethics is not a thing that would say that he's involved in any sort of evil. It's obvious that he's involved in the bigger picture, a very good endeavor. The situation really hinges on the voting thing, I think, in his mind, because the draft opinion is a roadmap for him to not have an impermissible conflict. In other words, he won't have to resign. It's not like, he has to get off or the school or off the, representing the school or off of the city commission. And the word agency in the voting conflict law is in essence an exemption to the requirement that you're not supposed to vote on a matter that affects a principal by whom you are retained. And if he, of course, admits that it is his principal, and it is, the school. And under the law, in any context, exemptions have to be narrowly construed. that is construed against the person who would seek to come within the exemption. And I think Mr. Schaefer in his comments and in the draft has laid out well why you just really cannot apply the government agency designation to a charter school that is an incorporated entity. That is, I think, the hard legal point here. And you are bound to follow the code as written, and exemptions are to be strictly construed. And secondly, having seen a lot of situations over the years where many public officials were involved in laudable endeavors, often the question is, when public resources are out there and you've got, let's say, 10 availabilities of public resources and you've got 100 good applicants that want to do good things with those resources, you have to have objectivity in the official decision making. As the court said in relation to another ethics statute that forced DCA years ago in the Zurich opinion, you really just have to generally look at whether or not a person's private interest and connections are separate and distinct from their public duties, or whether they coincide in an impermissible manner. And it's obvious that the interest of Mr. Gibson and his client very strongly coincide here with the responsibilities of the City Commission. And the Code of Ethics is written with its various elements and technicalities, but the essence of it is, under the voting conflict law and other provisions, is to make sure that officials are objective, even when they're choosing among or dealing with do-gooder, laudable organizations. It's not all cloak and dagger, impermissible money in the middle of the night. The idea is objectivity on all fronts. And I think he's got, a good thing going there, but I don't believe that his election, based on his candidacy, can have the effect of amending the state code of ethics, which is the province of the legislature. And I think Mr. Gibson is a very good man, but I think this would be an awful slippery slope to say that an incorporated entity that is not traditionally within government could be considered an agency for purposes of the voting conflict law. And I would echo everything that Mr. Schaefer said and that he has written. And if you had any questions of me, I'd be happy to answer them. But I have nothing against Mr. Gibson, but I think that really this is well laid out by Mr. Schaefer. Yes, sir.
I would echo what you said about Mr. Gibson. I appreciate being asked a question before you took action on it. That's always encouraging. Bridge the gap for me, though, in my mind, of where's the gain? Where is that gain for the agency, for the private school? And that's what I don't see that gain.
Yes, sir. If I might, Madam Chair. Essentially, gain is, or loss, economic effect, if you will, for purposes of the voting conflict law, is when value, and land is inherently valuable. This old facility inherently has a value as realty. When value goes out of the government, that is gain or loss to whoever receives that value, be it an award of a contract, be it money, be it land or facilities like this. The private nature of it comes in with the fact that the definition of business entity in the Code of Ethics, which is antithetical to the definition of agency in the Code of Ethics, includes among its enumerations any corporation. And the Commission on Ethics has said that it doesn't matter if it's for-profit or non-profit, a corporation is a private entity. And I believe one of the other commissioners, may have been you, may have been Mr. Brady, said that the classic kind of phrase you hear, non-profit does not equal no money. And if you take like Pride, the prison industries program, it's a non-profit. But I think from its beginnings, there's a lot of money that flows through it. And really what you have here is, do you want to have a subjective, predisposed view on a vote that is going to divest a municipality of a piece of property that inherently has value? The opinion doesn't say he has to leave his position. It just says he has to step back from votes regarding the entity to which he is connected. And beyond this opinion, the question would be, how good is a nonprofit such that it's not subject to the apparent elements of the law? And I think this would be a very slippery slope and disregard the decisional history of the commission in construing several of the statutes. But not to get off of your point, Commissioner Cox, but the voting conflict law is much broader than something translating into cash in the pocket of the person that is the agent or the face of something. Really, it begins when value goes out of government to a private entity. And I just don't think, with the full analysis of all the statutes, that you can say that a charter school is a government agency. And really, one of the selling points for charter schools is we're tired of the government schools, so we want to have different sorts of schools. And the appeal of a charter school is that it's not traditionally a government agency, that it's not in the straitjacket of the bureaucracy. And
ask you to wrap that up, just because I interrupted Commissioner Norris right when he was ready to ask a question. So if
I didn't mean to continue.
No, I just wanted to make sure I honored Commissioner Norris' patience.
Thank you.
Thank you.
Mr. Anderson can go on as long as he needs to. But thank you, Madam Chairman. I have a couple of questions, I think, and then comments. So I'm going to start with the broad question that I believe is properly addressed to the executive director through the chair. It may go to the council, I'm not sure. Seems to me that our commission is in a bit of a interesting situation. We've got very nice, well-drafted, recommended opinion. And let's just say, for supposition's sake, that a majority of the commission agrees with the majority of the opinion, but does not agree with certain points, in particular this particular conflict of interest point with respect to gain. On that, how on earth do we go about amending the recommended opinion?
Ms. Dawes, would you like to respond to that?
Of course. In the past, the commission has rejected the opinion. In this case, I would consider it a substantial modification, so we would go back and redraft. The problem is getting from here to there, so that if the commission has a difference of opinion with how it's drafted, it would be helpful to lay out exactly what it would like to see in the draft, because what I've heard Mr. Schaefer and Mr. Anderson say is that basically this is the only way they could see it going. But if the commission wants a redraft pointing in a different direction, we would take it back and come back at the next meeting with that. Since somebody gave me the opportunity to speak, I thought I'd throw this in. It's what I heard Mr. Gibson saying is that it's a little bit distasteful to suggest or to implicitly suggest that something underhanded might be going on here, which I think clearly there is not. There's no suggestion of that. There's no hint of that. I think a modification that could be made without bringing it back before the commission is to include something along the lines of, there's no suggestion from any information we've received that either the charter school or Mr. Gibson has been involved in any shenanigans. I wouldn't use that word in the opinion.
Total speculation on our part anyway, and so that I'm not looking to get there. I want to know what we do about redrafting certain points of this opinion.
So I'm just going to echo that, and I'll let other commissioners do as well, that when we have done minor modifications before, I know that we have come up with enough of a consensus for what those points might be. If we have consensus, then that gives the staff the ability to make another attempt. If we don't have consensus on what those points should be, then they really do not have any guidance from us, and we should consider then adopting the opinion. Commissioner Norris, you can follow up.
Thank you. If I may follow up. Mr. Gibson, you stepped away. You still had some time, but if you don't mind, I have a question for you, and we didn't quite get to that opportunity. I know that you started this process in coming to the commission, for which I commend you. We need more folks coming to the commission like this in advance for an advisory opinion, and you started that sometime back in June. And then I also know that charter schools, they generally try to start school in August of a year, and there's lead time for that. Where is this charter school with respect to the time frame of needing this answer with respect to an advisory opinion for you, and where is the city council in just in the time frame of any kind of transfer that would be made of this property?
The time isn't critical.
Time is not critical.
Time is not critical. If I may, I do have some time left, and I noted that someone else was given a chance to reply.
That was in a rebuttal situation, but at this time, if there's no objection from the commission, I'd like to give Mr. Gibson about 3 minutes, just because this is a particularly involved opinion.
Thank you. The key word here is private. And with all due respect, and Joe Madden, the manager of the Chicago Cubs, says when somebody says with all due respect, after that they can say anything. So with all due respect to the comments that were previously made, the Lake Wales Charter System is a public system. It's a public entity. It's a public corporation like a municipal corporation. The Constitution says that the district schools operate, manage, and control the public school system. The only place you can get a charter is from the district school because it controls public schools. The district schools have granted this charter to the Lake Wales system. We are an agency of that public agency. And as a result of the actions of the legislature this past session, it was always debated as to whether charter schools were a public agency. And one of the problems I have here and have had throughout this thing is people don't look at charter schools as public schools, even though the statutes say they are public schools. And just because they are not run by a district school board doesn't mean that they can't be public. The district school board could contract for somebody to run their schools if they wanted to, and that's basically what they did with us. They still have control. They can shut us down. We have to comply with all sorts of financial requirements because we're running public schools. And actually, the legislature solved the problem when this past legislative session they put an end to the debate. And they said, and only public agencies are granted sovereign immunity. Charter schools get sovereign immunity. I'll say real quickly, I have 17 seconds left. There are all sorts of charter schools. Our charter schools were the ones where we took over the existing schools. All kids, no elitism. We're responsible for the school. My time's up.
Thank you, Mr. Gibson. There may be a question, Commissioner Cox.
So I have a question. I'm trying to bridge that gap between where's the gain. And my first question was answered through Commissioner Lizenka that the land or the property will go back to the school system if the charter school fails or shuts down. So I don't see the gain there. But I guess it's that period of time in between. How will the school benefit by having this property in its control? Will it?
The whole purpose of what we're doing is not to benefit a school, it's to benefit students. That's why our board members are called trustees. I drew this stuff. The administrators don't raise a dime. All the money that comes to schools is on a per-student basis. So our board members are trustees. They serve in a trustee capacity for the real beneficiaries, which are the students. So the schools don't benefit, the students do. We have 400 students on a waiting list that want to get in to the school, and we don't have seats for them. So that's what we're about. And that's the way we're structured. You're not playing favorites with one school over another school, or with one, or I heard something about a prison. That's the legal structure. And the frustrating thing to me as a lawyer for 55 years is I can read the statutes. These are public entities. We're a public school system. And according to the legislature, we are a state agency. People want to say, well, you know, and as say, they didn't like the way government was doing things. So they switch over to private. We're not private. We're public.
Gibson, may I ask Commissioner Brady to pose a question?
If I was a public school, I couldn't have 400 kids on my waiting list. If I'm a public school, I am obligated, as I understand it, to find a place for those 400 kids inside my system, currently to the issues we're having facing people coming from Puerto Rico. As a charter school, you are allowed to basically say there's a fixed capacity, and we're not required to take students beyond the fixed capacity. Is that correct?
You know, there's the class size, which is constitutional, and I'm only about 80% sure of this. I think, and it's a legitimate gripe by the districts, it's on a classroom by classroom basis. With the charter schools, I think they say it can be on a school basis. In other words, you can have one classroom a little larger, another a little, but as a school, you still got to comply with the constitutional requirement for classroom size. So maybe that's a modification, but that's the best answer I can give you.
Madam Chairman?
Yes, Commissioner Norris.
Not for me to render any legal opinions or anything like that. I happen to dabble a little bit as an outside external general counsel for a school board up in North Florida, and we don't have to deal with, we do not get the opportunity to deal with charters very often, but we do. And number one, a charter school is by definition, under Florida law, established by the legislature in the charter statute as a public school. There is no two ways about it. It is a public school as a matter of law. Secondly, Commissioner Brady, going directly to your point, when charters apply to public school districts, they do just that. They apply to the public school district, and they apply under a certain parameter that says we expect we're going to have X number of students. And so that becomes their cap for that particular year unless they go back and get an amendment to their charter, which is their contract with the district, on the number of students that they can take. And that's how charter schools end up with waiting lists, because if the demand exceeds their supply of seats, they can have waiting lists by virtue of people want to get in. But if they don't have the facilities to have another school, build another school, occupy another school, then they don't take the students. And there's all kinds of politics that can get speculative, that go in and out of it as to whether or not they're trying to exclude certain types of students and all of those kinds of things. That's not before the commission with respect to the politics of charter schools. Is not before the commission with respect to this. Where I see a flaw in this opinion is that it is equating the public charter school system with, in essence, the private prison system as an example. And they're just two entirely different mechanisms under the law of a private-public partnership. And so, I'm going to vote against this recommended opinion despite my respect for our counsel on it, and it's well-written and what have you, but on that particular point, and with respect to, in effect, calling this charter school private, that operates under public funds at the pleasure and effect of the school districts, because the school districts have the right under appropriate circumstances set forth by the legislature to revoke their charter. It's a public school, and I see no private gain. Having said all that,
Can Mr. Gibson sit down?
No, I got it.
having said all that, when you're sitting on the city council, obviously there are circumstances where your credibility and your reputation is beyond reproach, and it needs to stay that way with, no question whatsoever.
I have to make that judgment. But I would say this, that people who seek public office, and I didn't come in as a school nut. I came in as a community redevelopment nut. But people who seek public office are entitled to have bias. Somebody could say, I'm biased in favor of sidewalks. I want to get pedestrians off the streets. I come in with a bias for public schools. Everybody knows that, who voted for me. And
Does anybody else have a question for Mr. Gibson? I have a question, and I will say this has been an extremely illuminating process. I think you acknowledged that it's been a new one for you, thankfully. Your
first time I've
and
ever
you
been
did
here.
it voluntarily. And I will disclose that I serve as general counsel to a charter school and share your belief
Oh, really?
in the importance of public schools of all sorts. And therefore, I have taken particular note of the significance that the employees of a charter school are not otherwise subject to the code of ethics. Am I correct on that? For the most part.
For the most part.
Not speaking of board members who have certain requirements. So if they are not subject to the code of ethics, can you help us understand how to align that truth with the designation of the charter school as an agency?
I read the opinion, and the opinion accurately stated that the charter schools were exempt from certain aspects of the code of ethics. But the important thing is, and it says so in footnote 6 of this opinion, it's not exempt from what controls this issue. And that the charter schools, it says, are subject to sections 112.3, 1, 3, 2, 3, and 7. 3 and 7 are what we're talking about. So we're subject, this issue that we're talking about now is subject to the code of ethics. The other stuff is irrelevant to this issue.
Thank you. We have tortured you long enough, and appreciate your serious consideration of this, along with this commission's serious consideration. I'm going to ask Mr. Schaefer, you may sit down and
Okay,
rest.
I'm afraid I've tortured you. So.
Thank you for that analysis. Mr. Schaefer, do you have any response to the question that I just asked and Mr. Gibson's response to it?
Well, my only response would be whether or not the charter schools governing board are subject to those provisions is not going to make a difference when it comes to whether or not they apply to Mr. Gibson. What we're talking about here is the application of those provisions to him in his capacity as a city commissioner.
understood, but does it help to see that one can be an employee or an agency for one legislatively created statute and not for another? I mean, in this case, a charter school can be a public school under the charter school statutes and not an agency under the ethics code.
The only thing I'll add to that is that in 2009, I've done some research on the legislative history behind that particular provision. And the legislature at that point had a choice. If you look at the staff analysis for the bill that affected the education code that year, what it says is that they were aware the code of ethics was being inconsistently applied to charter schools. And they had the choice at that point to make the entire charter school system subject to the code of ethics, like a public agency would be. But instead, they only hand-selected those particular provisions that would apply. So again, that buttresses my argument, again, that the legislature has treated charter schools differently than how it's treated.
For different purposes. Like
For-
it's treated one way, again, under the charter school statute and a different way under the ethics statute. That's the conclusion I have drawn from your analysis.
Yes.
Any other questions for staff or the attorneys? At this time, I would ask that you consider a motion. I know that this is a difficult one and probably one of the most studied, not just today, but this was originally on the agenda for our last meeting, so we've had a couple of months to consider, research, and study it. So at this time, I would ask for a motion from the commission with respect to this advisory opinion. Commissioner Brady?
I move to adopt the opinion as presented.
I'll
Is there a
second it for discussion.
Okay, it's been moved and seconded for adoption of the advisory opinion for discussion purposes. I think we've heard from Commissioner Norris with respect to what his comments would be as it relates to particularly one item, but may I ask you a question, Commissioner Norris? Would you, and you don't have to commit to your vote now, but I'm interested conceptually in whether you support the opinion with a modification with respect to the prison language, or do you not support the conclusion of the opinion because of that language?
I do not support the conclusion of the opinion.
And is that is just to question 3 or to all 3 questions?
3.
Okay. So I'll start.
Commissioner Rosenka.
I, too, disagree with the response to question 3. And although I don't look at the issue of agency per se, I think that's an oversight or an intentional oversight on the legislature, which maybe needs to be fixed. But I look at the special private gain, and I don't think there is a special gain in this particular circumstances. And in my opinion, advisory opinions are like case law. They're specific to the facts raised. And in this particular situation, I do not believe that question 3 as to the first part of it is correct, that if it is sold to the charter school, that there's a special private gain. And so I would like an amendment or a tabling to allow new language to come out, or we can send the chair out to rewrite it like we've done.
That was on the spot.
Yeah, that was on the spot, Johnny on the spot. So I don't know if we can adopt the response to question 1 and 2, or we send the whole thing back. But I can't accept it as is with question 3 answered the way it is.
So just to clarify, for our discussion purposes, the motion is to adopt the opinion in full. So if you choose to deviate from some portion of it, then you would vote against the motion. And then we can separately discuss how we would want to change it.
Or we can amend the motion.
Yes.
Right.
I think everyone gets a chance to discuss first, and then perhaps we amend, or perhaps we do something else.
Any other discussion? Commissioner Brady.
I can assure the commission that there is tremendous public gain for nonprofit corporations that receive large gifts from municipal governments in the terms of property, that it provides them a heightened awareness in the community, which is an incredibly important gain for nonprofits. It provides them with the capacity to raise additional funding, and all the charter schools I'm familiar with do additional fundraising to supplement the money, and really does accrue prestige and value to the corporation. Perhaps not to the general counsel, but to the corporation itself. And if the general counsel passed away tomorrow, the property would still sit in the hands of the private nonprofit corporation. I mean, if you want to take a position that the logic of including a charter school as a, I guess, a private corporation rather than an agency, way beyond my pay grade. But in terms of value and gain, those are tremendous value and gains for private nonprofit corporations to be handed property in a way some like the general counsel discussed. So I just want to make sure people understand that. If you have an issue about whether a charter school is an agency of government or a private nonprofit, I live in the city of Miami Shores. The city of Miami Shores has a municipal high school, charter school. I can assure you that the city commission in Miami Shores and the city manager in Miami Shores does not regard it as an agency of Miami Shores. It regards it as a private nonprofit corporation to which the city supports to the extent it needs to be to benefit the citizens of Miami Shores. I mean, again, that's my impression. And when I look at the general discussion of charter schools, particularly in Miami-Dade County, one never gets the picture that's presented by Mr. Gibson.
Thank you, Commissioner Brady. Any other comments, particularly from anyone who's not spoken on this issue yet? Hearing none. Commissioner Rosenka, did you have another comment?
No, I don't. I was looking at Commissioner Berger to see if he was going to.
I 1 and 2 make sense. 3, we kind of haven't gotten into, and maybe it's not the correct issue, and I don't question the petition in any way, shape, or form. In fact, I commend you, sir, for your efforts, for your service to your community. The appearance of impropriety of both being the council and voting on these issues is one of the things that's rolling around in my brain. The legal issue, I mean, I'm hearing both sides and I'm kind of split, but on the commission and then being the counsel for the charter school, that's concerning in regards, irrespective of whether there's no impropriety in and of itself. So, I'm not really exactly sure what the motion is on the table. I know that I think we're hearing that everybody agrees with 1 and 2, and we're looking at 3 at either amending it or voting on it as is. Is that correct?
Right now, the motion on the table, as stated, is to adopt the opinion as written in full. So that would include the recommendation with respect to number 3. Any other comments, questions, or discussion? Mr. Schaefer.
I have a thought as I'm sitting here. Perhaps the general counsel would like to correct me if I'm wrong.
And let me just say, because I'm thinking that Mr. Schaefer may have somewhat of a solution, I'm going to allow him to comment during this. Yes. Otherwise, what would just be normal debate. Thank you.
The issue here appears to be whether or not that exception to the voting conflict statute will apply, whether or not a charter school should be considered a public agency or not. Even setting aside that question, even if you take question 3 out of the opinion, though, and you just look at the first 2 questions, he's still, and I'm not sure if this would influence your eventual vote or not, but he still would have a conflict if he participated or voted on any measure transferring title to that property, if he knew that it was going to end up eventually at the charter school. And that's because the second part of subsection 7A applies if one has an employment or contractual relationship that could impede their ability to perform their public duties. He clearly has a contractual relationship with a charter school here. And when it comes to the second part of 7A, the analysis is whether anyone has an employment or contractual relationship that could tempt them to dishonor their public position. I think an argument could be made here that because of his private contract with a charter school, there are some questions about his objectivity if he were to vote or participate in the vote about this title transfer issue. So my whole point, and I hope it's helpful, is that even if you take question 3 out of the opinion, the ultimate result of the opinion will still stand based just on analysis 1 and 2, questions 1 and 2.
The conclusion would be the same if you omitted number 3. You would still have,
I believe that it would. I believe that it would.
I don't think so. We're talking, not if they use a separate council to transfer title.
I'm sorry?
Question 2 says if they use separate counsel to transfer title, then he doesn't have to refrain from voting. That's under question 2.
Well, in that particular case, he's still, even if they use separate counsel to transfer title, he still couldn't take any actions as a city commissioner that would benefit a private employer that he had a contractual relationship to, or in this case, an entity or an agency that had a connection to. Even if they use a transactional attorney, he still would not be able to participate under the second part of 7A.
Mr. Anderson.
Just briefly, what Mr. Schaefer is referring to there is that the factual predicate for his not having a conflicting employment or contractual relationship under question 2, where there's, I think, a gifted transfer, a factual predicate to his reality not being conflicting is that he stay out of it, which would include not voting and not participating. So just the voting conflict statute alone will not free him in this situation, even if you didn't go with question 3, because the predicate under question 2 is that he not be involved in his public capacity as a council member.
Thank you. And if for any reason a commissioner was interested in changing question 3's analysis or omitting it, we would still send it back to the commission staff for revisions, meaning that you would not support the motion if you wanted to have that kind of modification. Is that clear?
Well, with that,
As opposed to trying to
with
redraft
that,
it.
is question 3 necessary? I guess that's a question for Mr. Gibson.
He asked it, right?
Right. I guess it is.
Mr.
Okay.
Gibson,
No,
we,
yeah, go ahead.
we've kind of had all of us, maybe an immediate conclusion that just by the very nature of having asked question 3, that we are in a posture of answering it. And now that it's part of the advisory opinion, I again think that's what's on the table. So no comment necessary. I just wanted to clarify that for you as well as for us. Any other discussion? Hearing none, all those in favor of the motion to adopt the advisory opinion as written, please indicate by saying aye.
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 All those opposed?
Nay.
Okay, I'm going to ask for a roll call vote.
Commissioner Akers?
Yay.
Commissioner Berger?
Yay.
Commissioner Brady?
Yay.
Commissioner Cox?
Nay.
Commissioner West?
No.
Commissioner Uranga?
No.
The vote is a tie, in which case the motion fails. And I'm sorry that we do not have the full commission here today to be able to consider this meaningfully. But with that, this means that this advisory opinion will be referred to staff for further consideration and will be in communication with you, Mr. Gibson, about how to move forward. I don't think that you need any more accolades. But I will just tell you that the next time my son has a civics project, I'm going to send him to you as a case study in citizenship. The whole reason that Mr. Gibson brought this here really has to do with his principled belief that he should be able to exercise his voice as he was elected to do, and regardless of how the analysis comes out on that, I think all of us express our appreciation for you as being a model for all of us. With that, you may leave, and thank you to who I presume is Mrs. Gibson for being a partner through this process as well as through both of your volunteer efforts.
Thank you.
At this time, we are going to take one more advisory opinion before we take a break. That will be File 2699, presented by Caroline Klenke. Is the requester here for that opinion? Bring in Ms. Klenke.
Good morning, Commissioners. I'll be brief. File number 2699 arose from an inquiry posed by the Superintendent of Nassau County School District regarding whether any provision of the Code of Ethics would prohibit the superintendent from recommending an award of a construction contract to a company that is partly owned by her adult stepson. The provision of the Code of Ethics most germane to this analysis is Section 112.313, subsection 3, which provides in relevant part that the superintendent is prohibited from acting in her official capacity as a purchasing agent, from purchasing services from a business entity of which the superintendent, her spouse, or her child is an officer, partner, director, or proprietor, or in which the superintendent, her spouse, or her child has a material interest. Clearly, the adult stepchild of the superintendent in the instant case has a material interest as a one-third owner of the construction company in question. However, for the reasons described in greater detail in the opinion, it is proffered that the prohibition in the first part of Section 112.313 subsection 3 is inapplicable in the instant matter because the term child, as it is used in this prohibition, does not include a stepson. This analysis is supported both by the legal definition of stepchild or stepson, as well as case law analyzing the rights of adult stepchildren or the lack thereof in certain circumstances. Similarly, the provisions of Section 112.313 subsection 7A are also inapplicable to create a prohibited conflict of interest in the instant case because this provision prohibits, as was previously explained, certain contractual or employment relationships of the public officer and not that of those individuals who are arguably relatives. For these reasons, we submit this opinion for your consideration, and staff is available to answer any questions you might have.
Thank you, Ms. Klenke. Are there any questions for staff, council? Hearing none, I would Commissioner Brady.
So children are not covered by, stepchildren are not included in the nepotism statutes?
Okay, so that is actually analyzed in the instant case as well. These are two separate statutory provisions. The provisions of the nepotism statute use the term relative, which includes a large group of individuals, which includes stepchildren. In the instant case, we're looking at the conflicts of interest statutes, and in particular, that which is contained in Section 112.313 subsection 3, which is not the nepotism statute. It does not use the term relative, but rather uses spouse or child.
Articulates a set of,
And child is not defined within the statutory provisions. However, in accordance with the way we have interpreted the nepotism statute's definition of relative, we have been very careful so as not to expand the liability beyond the terms which are contained in those provisions.
Thank you. Any other questions? If not, I would entertain a motion regarding the advisory opinion.
Motion.
Commissioner Berger moves for the approval of the advisory opinion. Is there a second?
Second.
Any discussion? All those in favor of the motion to adopt the advisory opinion, please indicate by saying aye.
Aye.
Any opposed? The motion passes. We will take a 10-minute break, and we'll begin promptly at 10:35. Commissioners, with your indulgence, we are going to take a slight modification of the agenda because of some travel issues that involve under item 9, appeal number FD 16-067. The appellant is Carla Hart. Is there any objection to taking up that matter at this time?
The chair.
Yes. Mrs. Hart, are you here? Oh, thank you. Thank you for being here. Ladies and gentlemen, item 9 on our agenda consists of appeals of automatic fines under the financial disclosure law. First, we will take up the appeal involving Mrs. Hart, for which the appellant, Mrs. Hart, has requested a hearing, and then we'll go back to our advisory opinions and then make our way back to the other financial disclosure matters. Mr. Knight, do you have a recommendation with regard to this matter?
Yes, Madam Chair.
Would you please make
Madam
that?
Chair, members of the Commission, you have a draft final order before you for your consideration. This case involves Carla Hart, who was employed as a principal with Broward County Public Schools in a position that she was required to file a CE Form 1 for the year 2015. No later than June 1st, 2016, the Broward County Supervisor of Elections sent her the CE Form 1 to complete. That mailing was sent to 8220 Northwest 45th Street in Lauderdale, Florida. No later than July 31st, 2016, the Broward County Supervisor of Elections sent her a notice of delinquency by certified mail. That notice was returned by the post office marked "Return to Sender Unclaimed." On August 17, 2016, the Commission mailed appellant a postcard to remind her of her obligation to file a 2015 CE Form 1. That postcard was mailed to the same address. On September the 7th, 6 days after the grace period expired, the Commission mailed her a courtesy notice informing her that an automatic fine had begun to accrue. That notice was also mailed to the same address. On September 21st, 2016, Commission staff emailed her to remind her of her obligation to file the form and that an automatic fine was being assessed against her. On November the 2nd, 2016, Commission staff again sent her an email with the same reminder. On November the 2nd, appellant called the Commission after receiving the email and told Commission staff she did not know why she had to file a CE Form 1 and did not recall having received any notices concerning her financial disclosure obligation. Commission staff advised her as to why she had to file the form and of her right to appeal the fine. The amount of the fine assessed against appellant was $1,500. On March the 9th, 2017, the Commission mailed her a notice of assessment of an automatic fine with her right to appeal, again to the same address. On March 28th, she submitted her appeal, and in her appeal, she listed her address as the 8220 Northwest 45th Street address to which all Commission correspondence had been sent. On May 22nd, in her appeal, she stated that she's not really sure why she did not receive the notices, but was willing to do whatever it took to rectify the situation. On May 22nd, 2017, I emailed appellant advising her of her filing obligation that she still needed to submit her 2015 CE Form 1. On June 27th, 2017, I called appellant. Appellant acknowledged receiving the May 22nd, 2017 email, but stated she got confused because she had received a notice from the Broward County Supervisor of Elections about the same time regarding her 2016 form. She did state, though, that the 8220 Northwest 45th Street address was her correct address. She also stated that she remembers receiving the notices in the mail, but since she had recently been hired as a principal, believed that the notices were junk mail. I again advised her of her obligation to file the CE Form 1, and she stated that she would email it to the Commission the same day. On June 27th, appellant did submit her 2015 CE Form 1 to the Broward County Supervisor of Elections. Appellant's basis for the appeal of her fine is that she failed to timely file her form due to lack of notice. However, appellant verified to me that she did remember receiving the notices in the mail, but believed them to be junk mail. As such, she has not pointed to any uncommon, rare, or sudden events that prevented her from filing the CE Form 1 in a timely manner, and therefore has not identified any unusual circumstance that would justify waiver of her fine. Therefore, we recommend that the Commission affirm the assessed fine of $1,500 and deny the appeal.
Thank you, Mr. Knight. Are there any questions for Mr. Knight? Hearing none. Mrs. Hart, would you like the opportunity to speak? Technically, I'll give you 15 minutes.
Okay.
I don't know that you'll need it.
Okay, thank you. I'd just like to say good morning, first of all, Commissioners, and thank you kind of for adjusting your agenda so that I can make it back to Fort Lauderdale. My name is Carla Hart. I am a proud principal at a public school, elementary school, where we service pre-K students all the way up to 5th grade. In 2015, I was appointed as the proud principal at that school. Now, let me take you back and give you the framework of Larkdale Elementary. Larkdale Elementary School is a low socioeconomic school where a lot of my kids, they come from different backgrounds. Every morning, on morning announcements, I greet each of my students on morning announcements, and one thing that I always talk about are morals. And when we talk about code of ethics or what have you, it kind of saddens me that I'm here. But I just want you to understand that no intention, this was not done intentionally. I was placed at a school where I worked 15 to 16 hours every single day trying to move an F school off that state mandated list. And it was just mailed back and forth or what have you. When I spoke to the gentleman, I explained to him. However, when I found out what the situation was, I explained to him that I would be more than happy to rectify the situation because it was not done intentionally. Once I found out what I needed to do, I followed the processes. I made sure that I did file my financial disclosure for the 2016 school year. What have I done differently now? I am a mentor to new principals or what have you, and we get a lot of mail, especially from the supervisor of elections or what have you, and that was during, election time or what have you. So it was just a lot of mail I didn't look at or what have you. But when I found out what the circumstances were, I made sure that I filed the papers that were asked for. Okay?
Thank you, Ms. Hart.
Okay.
Any questions for Ms. Hart?
Will this fine have any implications on your position?
I'm sure it would, probably so, if I'm not mistaken. So the purpose of me coming here is just to rectify the situation and asking, before pre-Hurricane Irma, my thing was to come here and pay my fine, okay? A lot of things have changed financially during that time, so I'm really asking for you guys to reduce the fine. I don't have a problem paying it, but if you can just have a reduction of the fine.
Any other questions? Commissioner Berger.
How long was your drive from Broward?
Oh, ask my husband. It was 6-7 hours. We got here about 2 o'clock this morning. But I just wanted to make sure that I was here in person, and it just happened to work out that today is a teacher work day, so I have a problem with taking off work when my students are there, especially trying to move a low-performing school. So today just worked out for me where it's a teacher work day, and he was able to bring me.
Appreciate your service and appreciate you coming
Thank
up here
you,
to address
Commissioner.
us face-to-face.
Thank you.
Any other questions for
It
Ms.
is
Hart?
my understanding that we can work out payment programs for people that have files, so that would not take, you don't have to write a check today, but we can work out something where
That's
basically
correct.
you can, okay, thank you.
Any other questions?
Just one other question. Have you ever had to file the Form 1 or Form 6?
No, because this is my third year, starting this August, this is my third year as a school principal. Prior to that, I've never had to file. So my 2015 was my first year as a principal. 2016, it was my second year, and I did file.
When you were appointed to your position, did they explain to you that that was a position that needed to be?
Not really. It's, hey, congratulations, you're the new principal at the school. You must move the school off the state list. So that wasn't really a part of the conversation when I became a principal. However, I am a principal mentor to other principals. And every year, at the beginning of this year, when I met with my new principals, I made sure that that was on the agenda because I don't want them to find themselves in a situation. Our work is hard as it is. And we get a lot. I mean, especially when you're working at a low-performing school, those principals are doing 15 to 16 hours a day. So looking at mail and going through mail, I'm just going to be honest about it, we don't really do that. So.
Any other questions for Ms. Hart? Not, thank you.
Okay, thank you.
And for your remarks.
Okay, thank you.
I'm going to ask Mr. Knight if you'd like the opportunity to respond or comment.
Thank you, Madam Chair. I just wanted to mention a Commissioner Brady, you brought up the issue of the payment plan. The payment plan is available in order for her to pay the fine, but the situation here is that we have a potential willful case here, where the predicate for an investigation to determine whether the failure or refusal to file was willful are that, number one, the person be in a public position, which includes, in this case, a principal if she has the appropriate spending authority, and number two, that she has a $1,500 fine. So putting her on a payment plan is not going to change the fact that she still has the fine assessed against her that would be one of the predicates for a possible willful investigation.
Are there any other questions or comments from Mr. Anderson, please?
Just briefly, thank you, Madam Chair. What that would mean is that if you have a willful investigation, it would be a whole other proceeding with the possible ultimate outcome being this commission having to recommend removal from her position. And if her fine were something less than $1,500, you wouldn't have the predicate for the willful violation. And we've had a number of people that have made a trip up here just for the willful thing, and she's made one now for this. And on those willfuls, a lot of those have been handled such that the person didn't have to be recommended to be removed, and they made the trip way after the big investigation. She's come up here on the front end, but if her fine remains $1,500, even on a payment plan, she might have to come up here again, and there might have to be a lot of commission resources expended on a willful investigation. But that's up to the will of the commission if you see any just reason to reduce the fine below the $1,500.
Madam Chair.
Thank you. Commissioner Cox and then Commissioner Brady.
I'm going to make a motion that we reduce the fine to $500.
There's a motion to reduce the fine to $500, but otherwise accept the recommended order. Second, is there any discussion? All those in favor of the motion, please indicate by saying aye.
Aye.
Any opposed? The motion passes. Thank you.
So
Thank you.
do we need to do something with the petition, or does that do it with the petition?
That,
Okay.
that will just be modified in the order that is ultimately issued.
And maybe I didn't hear it good, but is that reduce it to $500 or by $500?
To $500, yes.
Thank you. Keep trying to do good.
Thank you.
Now we'll revert to our normal agenda, which will address File 2700, the advisory opinion regarding disclosure of financial interest and involving the finance director of a county, municipality, or other political subdivision. Is the requester present? No. Thanks. With that, I'll ask Ms. Daly to please make your presentation.
Thank you, Madam Chair. This one's really short. This opinion was requested by the county attorney of Monroe County on behalf of the Monroe County Commission and Clerk of Court. The question is whether Monroe County employees in two specific positions are required to file annual financial disclosure. These positions are Senior Director of Budget and Finance for the county and Finance Director for the Office of the Clerk of Court. After analyzing the duties of these two positions, we concluded that the Senior Director of Budget and Finance is the Finance Director of the county and therefore is a local officer required to file financial disclosure, and that the Finance Director within the county clerk's office is not a local officer within the meaning of the financial disclosure statute. This is in accord with the Commission's opinion CEO 13-17, stating that a finance director within a sheriff's office is not a public officer. Therefore, of these two positions, only the Senior Director of Budget and Finance is required to file CE Form 1 Statement of Financial Interest. And this opinion would be really just only directed at Monroe County. The draft opinion is presented for your consideration, and I will be glad to address any questions.
Any questions for Ms. Daly?
Move for approval.
Commissioner Cox has moved the approval. Is there a second? Second. Any discussion? All those in favor of the motion to adopt the advisory opinion, please indicate by saying aye. Aye. Any opposed? The motion carries. Thank you, Ms. Daly. The next advisory opinion is file 2701, a conflict of interest issue regarding the Board of Governors of the State University System. And I would ask if the requester for that opinion is present. Thank you. Could you please announce your name for the record?
Certainly. Vicki Shirley, General Counsel, Board of Governors.
Thank you, Ms. Shirley. And presenting this opinion on behalf of the staff is Mr. Chris Anderson.
Thank you, Madam Chair. This opinion deals basically with a company of which a member of the Board of Governors of the State University System, not a member of the Board of Trustees of the particular university that's discussed in the opinion, but the bigger overall board. His company would desire to donate land, money, or services to a state university, and also the university would have a contract with a health care provider, and it has to do with the members' company's development of a residential property in Southwest Florida. The opinion goes through the various elements of the statutes and concludes that there would not be a prohibited conflict of interest under 112.313(7)A or any of the so-called status offense statutes. But the opinion does make the point in footnote, which will become an end note if you adopt the opinion on page 4, I believe it is, that if there are any votes of the Board of Governors that relate to the donation of the property, and there may be none, that because land is inherently valuable, there would be an economic effect on his principal or his company if they donate land to the university, sort of a reverse dynamic from one of the matters you heard earlier here today. But this opinion basically concludes that there is no prohibited conflict for the member under these circumstances, and that, but he would have to abide by the voting conflict law should any measures affecting the donation of land or other things regarding his companies manifest themselves. I would offer this for your consideration, and if you have any questions, I'll try to answer them, and I think Ms. Shirley is available if you had anything for her. Thank you.
Thank you. Any questions for Mr. Anderson? Ms. Shirley, would you like to make any remarks?
Madam Chair, we just urge the commission to adopt the opinion.
Thank you.
So
Commissioner
moved.
Brady.
Move to adopt the opinion as presented.
Second.
It's been moved and seconded to adopt the opinion. Is there any discussion? Hearing none. All those in favor of the motion, please indicate by saying aye.
Aye.
Any opposed? The motion passes. Thank you, Ms. Shirley, for asking for the opinion, and would you extend our thanks to Mr. Kitson as well. At this time, we'll move to file 2702 regarding a conflict of interest and gift acceptance involving city commissioner appearing at events and in media platforms. I do not believe there's a requester here. If so, please stand. Back to you, Mr. Knight.
Thank you, Madam Chair. As you have read in the draft opinion, this request is brought by Marlon Bolton. He's a city commissioner with the city of Tamarack. There are two questions presented in the draft opinion. First one is, would a prohibited conflict of interest exist were Commissioner Bolton to retain a public relations firm to identify, create, and engage meet and greet events and media platforms through which he may gain exposure in the community? And second, would services provided to Commissioner Bolton by the firm constitute a gift to him under Section 112.3148, where he has engaged a firm to promote him and to assist him with gaining exposure in the community and has paid fair market value for the services provided by the firm? As stated, this opinion is requested by Commissioner Bolton, and that he plans to retain a public relations firm to provide him with certain services to allow him to assist with his community outreach. The firm that he proposes to work with is not doing business with the city, nor is it regulated by the city or the city commission in any way. The city commissioner anticipates the firm setting up meet and greet events, which would include breakfasts, luncheons, galas, networking events, seminars, festivals, fun days, sporting events, and other events and mediums. The firm would also help the commissioner gain exposure by creating mobile platforms printed materials, podcasts, social media posts, and other types of media advertising. The firm may engage businesses in the community to sponsor some of the events and platforms. Finally, he relates to us that his participation on some of these platforms may be at no cost to him, where he is invited by the firm and the same opportunities are opened up to other elected officials at no cost. The first part of the analysis in this draft opinion deals with Section 112.313(7)(a). As you've heard now several times, that the first part of that statute prohibits him from having an employment or contractual relationship with any business entity regulated by or doing business with his agency. As the firm is not doing business with the city, nor is it regulated by the city or the city commission, the first part of this statute does not apply to the situation presented. As you've also heard, the second part of Section 112.313(7)(a) prohibits him from having any contractual relationship that will create a continuing or frequently recurring conflict between his private interests and the performance of his public duties. Nothing in the information that he has provided, including the fact that the firm's owner serves with him on the board of a nonprofit organization, suggests this or any other conflicting dynamic. Therefore, the second part of the statute does not apply to the situation presented. Therefore, as to the first question presented, we recommend finding that hiring the firm to assist him with community outreach, including setting up meet and greet events and other advertising, will not create a prohibited conflict of interest under Section 112.313(7)(a). The second question presented is, would services provided the city commissioner by the firm constitute a gift to him where he has engaged the firm and where he has paid fair market value for the services provided by the firm? Section 112.3148 provides that when a recipient has provided equal or greater consideration for an item, the receipt of the item does not constitute a gift. This commission has previously opined in CEO 9145 that passes and tickets to a golf tournament from a tournament sponsor did not constitute a gift to a mayor who had provided equal or greater consideration for the tickets. To the extent that the city commissioner, therefore, provides full and fair market value to the firm for the meet and greet events and the other media platforms, they do not constitute a gift under Section 112.312 and therefore are not prohibited or required to be reported under Section 112.3148. The materials provided to us, however, indicate that Commissioner Bolton may be invited by the firm to attend events at no cost to himself, where other elected officials are also invited. And at this time, it is not clear who will pay for these events or whether he and other elected officials will be asked to share in the cost of these events. He states that he believes that the firm may engage businesses in the community to sponsor these events, but he is unsure as to the specifics of such sponsorships. These scenarios could possibly implicate the gift laws, since the Commission has previously opined that free publicity may be a gift. Therefore, as to the second question presented, we recommend finding first, to the extent that the City Commissioner provides full and fair market value to the firm for the meet and greet events and other media services, they do not constitute a gift as defined in Section 112.312(12)(a), and therefore are not prohibited or required to be reported pursuant to Section 112.3148. And second, the Commission cannot render an opinion as to whether the events or platforms funded or sponsored in whole or in part by others may be a gift, and if so, whether those gifts would be prohibited or required to be reported. We can only recommend to Commissioner Bolton that prior to accepting anything for which he has not given equal or greater consideration, that he review the gift statute and the Commission rule that has been adopted, which sets forth the various factors used to determine whether a gift or an indirect gift has been made. We further invite his inquiry as necessary when such additional facts become available. Thank you, Madam Chair, and we offer this draft opinion for your consideration.
Thank you. Any questions of Mr. Knight? Hearing none, I'd entertain a motion regarding this advisory opinion.
Move for approval.
Commissioner Cox moves the approval as written. It's seconded by Commissioner Norris. Is there any discussion? All those in favor of the motion, please indicate by saying aye.
Aye.
Any opposed? The motion passes. Thank you, Mr. Knight. We'll move to file 2703 regarding post-employment restrictions. I do not believe the requester is here. Therefore, I'd ask Mr. Schaefer if you please make
Over here.
Oh, did we get one? Good morning. I'm so sorry. Our notes said that you might not be here. Thank you. Would you please introduce yourself for the record?
Yes, I'm Anthony Glover.
Thank you, Mr. Glover. Sorry to not notice. Now, Mr. Schaefer, would you please make your remarks?
Thank you, Madam Chair. This draft opinion is a very straightforward application of the post-public employment restriction found in Section 112.313, subsection 9A4. Prohibits a public employee serving in an SES or SMS position from representing clients for compensation before their former agency for 2 years after leaving public employment. Now, Mr. Glover is a former employee of the Department of Business and Professional Regulation, and he worked in 2 positions while at DBPR. First as the Deputy Division Director for the Division of Alcoholic Beverages and Tobacco, then as the Director of the Division of Pari-Mutuel Wagering, and then he left Pari-Mutuel Wagering when he left DBPR entirely, when he resigned from public employment. Both of his positions are SMS or SES, and he's now wondering, going forward, how that 2-year representation restriction will affect his ability to represent clients before DBPR. And as the draft explains, if you look at the statutory definition of an agency and the Code of Ethics, it breaks down a governmental entity into its distinct parts, including breaking it down into its separate divisions. So each division is its own agency. So it stands to reason here that Mr. Glover's agency is not the entirety of DBPR, but just the individual divisions where he worked. So he'll be prohibited for 2 years from the date he transferred out of the Division of Alcoholic Beverages and Tobacco from representing clients for compensation before that particular division. And he'll be prohibited for 2 years from the date he left public employment from representing clients for compensation before the Division of Pari-Mutuel Wagering. This employee situation is a little tricky because we're dealing here with 2 separate 2-year prohibition periods, one corresponding to the Division of Alcoholic Beverages and Tobacco, the other corresponding to the Division of Pari-Mutuel Wagering. But because the opinion recommends finding they are 2 separate agencies based on the statutory definition of an agency, it seems that each of them will get their own 2-year prohibition period. And the end of the opinion addresses his question of whether he can advise clients about the subject matter that he might have worked on while at DBPR. That doesn't appear to trigger the statute so long as he isn't directly representing them before the divisions where he worked during that 2-year period. I offer this draft opinion now for your review, and I'm happy to answer your questions. And I'm sure Mr. Glover would be willing to answer questions if you had any of him as well.
Thank you. Any questions of Mr. Schaefer? None. Mr. Glover, would you like to make any remarks?
No, I agree with the opinion, and I will file it.
Thank you. Thank you for asking for it from the outset. Much appreciated. Hearing that, I would entertain a motion regarding the opinion. Moved for approval by Commissioner Norris and seconded by Commissioner Rosenka, and thirded by Commissioner Carson. Do you have some remarks? Would you like to make some remarks?
If I could. As always, it's a well-reasoned opinion, consistent with prior commission opinions. Let me rephrase that. It's a well-reasoned draft opinion consistent with prior commission opinions, and consistent with what is not an unreasonable reading of the law. I am concerned that we're getting a little too cute with how we're defining agencies. I know the most off-cited one, prior opinion, is dealing with the different geographical regions within the Department of Transportation, saying, well, if you worked in Region 1, then that's your agency, and therefore you can represent other people post-public employment in the other geographical regions. Definition of agency is department, and DBPR is a department. And I think the fact that Mr. Glover worked in ABT, Alcoholic Beverages and Tobacco, and then went over to PMW, Pari-Mutuel Wagering, indicates that there is some carryover between the 2 jobs he had. His expertise was valuable in both of those places. And so I think this is a good example of a situation where the agency that Mr. Glover worked for was the Department of Business and Professional Regulation. Obviously, I have no problem with him trying to find gainful employment outside the public sector. And I wish him the best in that. It's just, I feel like these types of opinions put us down a path where, we're looking for the smallest possible compartment that we can call an agency and saying that was the agency that you're prohibited from representing clients in front of down the road. So with that off my chest, I just wanted to have that out there.
Thank you, Commissioner Carson. Any other comments or discussion? Commissioner Brady.
Could we request the staff to really look at that, because I do believe that's a point I had paid absolutely no attention to and is fairly important, and really talk about the issue of the senior management in these departments really do form relationships between division directors and the actual directors of the department, which does provide them with kind of a wider scope of knowledge and influence than that is which is related to a really small subpart. And that we should at least, not in terms of the opinion, we should at least, get the staff to kind of look at that and review that and think about that a little bit to see if we haven't really, my assumption is that the public and the legislature wants that to be expanded as wide as possible, and we are kind of making it very specific and very small.
And if I could,
Commissioner Carson.
I'd like to sign on with what Commissioner Brady just said as a more thorough and better explanation of the point I was trying to make.
Any other comments before I ask Mr. Schaefer or Mr. Anderson?
Thank you, Madam Chair, and Mr. Schaefer may want to address this. I was interested, the nomenclature thing, the commission has a lot of opinions determining the meaning of agency, both in the context of a post-employment revolving door restriction and in the context of a concurrent secondary employment under 112.313.7a. And that has been harmonized for some years now to break down the agency, because while the definition of agency does say any department, or it says any division or bureau therein. And so the commission's view has been sort of a factual inquiry at times as to influence. And we had an opinion not long ago where an attorney for the Department of Revenue was deemed to have the entirety of the Department of Revenue as his agency, because he actually worked and had influence and responsibility in nearly all of the department as a lawyer, that sort of thing. And Mr. Schaefer, do you know if there's any factual predicate here where the requester would have deemed to have bled over to other parts of the department, or is he pretty well separated?
Well, looking at his request, it says, I have not been employed in any other capacity at the department and had no formal or informal responsibilities for any bureau outside of ABT and PMW.
Mr. Schaefer, did you want to make any other comments supplemental to Mr. Anderson's?
The only thing I will say is that the precedent is pretty clear about this. I think the law changed in 2011, where we started to look at the individual divisions or bureaus within an agency when trying to define what that term would mean.
Any other comments or debate? If not, the motion on the table is to adopt the opinion as written. It's been seconded. All those in favor of the motion indicate by saying aye.
Aye.
All those opposed?
No.
The motion passes. At this time, we will skip down to, again, Section 9. We've already taken care of the first item on that agenda. We'll move to the no hearing matters, and would ask if anybody needs to take any of those in that list separately. Hearing none, I would entertain a motion that we consider those en masse.
So moved.
And a second?
Second.
Mr. Cox, I should have clarified, did your motion include that you adopt the recommendations of the staff on those matters, or just that we take them up all together?
That we adopt the recommendations of the staff.
Thanks.
And that's my intended second.
Any discussion? All those in favor of the motion indicate by saying aye.
Aye.
Any opposed? The motion passes. At this time, we move on to the riveting portion of this agenda, which is rulemaking. And in this case, it should be relatively notice for changes to Chapter 34-8, which governs our financial disclosure forms. The purpose, as you know, of this public hearing is to allow the commission to hear the public comment, evidence, and argument about these proposed changes. And following that hearing, then the commission will decide whether to make any changes in response to those comments and whether to adopt the rule as noticed. The commission has the ability to withdraw a rule in whole or in part, or to make such changes as are supported by the record or the documents that we have received. The commission also may make technical changes which do not affect the substance of the rule. Ms. Doss, I would ask you to summarize these rule changes.
Everyone try to stay awake. These are the adoption of our financial disclosure rules. They are pretty bare bones. We have to change the dates every year. And on these, with the Form 1s, Form 1F, and Form 1X, we also point out that, as you know, starting last year, we started accepting those when they were sent in via email, and we point that out and tell people how they can send their forms to us via email. The Form 6s still cannot come via email. They have to be sworn documents, but the Form 1s can. So it's the date and that is the change.
Thank you. Is there anyone from the public that would like to be heard on these proposed changes? Hearing none. I think that since we've heard none, we can adopt these changes all at one time. I would entertain a motion to that effect.
So moved.
An enthusiastic motion to approve these changes. Is it seconded?
Second.
All those in favor, no discussion, please indicate by saying aye.
Aye.
Any opposed? Thank you. At this time, I'd like to ask if the executive director has any reports.
I do. Let's see, there's a couple of things since the last meeting. To start with the fun stuff, we didn't get to talk about this in September because there was no September meeting, but on August 25th, we had what we call Phone Fun Day, which is where we get on the phone and call filers who haven't filed their disclosure forms yet. We had 1,440 delinquent filers at that time. We made 723 calls that day. At this moment, there are no people who filed Form 6 who have not yet filed. They might have been late, but they filed. There are 22 state-level Form 1 filers who have not yet filed, and there are 128 local Form 1 filers who have not yet filed. So out of 38,000 filers, there are 150 who have not yet filed. And I want to commend Kim Holmes and her staff in disclosure. They move heaven and earth to try and get these people to file. Also, on a happy note, I should announce that Investigator Bob Malone had his 30th anniversary with the commission. Stand up, Bob. On September 14th. Investigator Keith Powell will have his 30th anniversary on November 2nd. You have so much with the fun part. At the last meeting, you asked me to conduct a status inquiry on the pending orders imposing penalties. With respect to the governor, there are 1, 2, 3, 4, 5. 3 of those have to do with the audits. I know that they're working on those, the audits of lobbying firms. I know they're working on those because they called over and spoke extensively with Caroline Clanky. I talked with the governor's general counsel on this. The first one, Michael Murphy, we have since learned that was a willful financial disclosure for which the only penalty is removal from position. We have since learned that he has left his position, so I have a call into the governor's office to let them know about that. That only leaves Jeffrey Doc Solomon. I don't know the status of that. They said they would look into it, but I haven't heard back from them. With respect to Jim Norman in the Senate, I spoke with the Senate General Counsel, who was extremely responsive on this and actually spoke with the Senate President. Their consensus was that this was not during President Negron's term, not during the term of the president before him or the president before him. It was during President Herodopoulos' term, and given the length of time that has passed and the fact that they don't really know whether President Herodopoulos did anything with it or not, they don't really feel it's appropriate at this point to take further action on it. So I don't think anything is going to be happening with that. I spoke with staff in the House. I got a similar answer. In all of this, it was pointed out to me that they don't have to do anything. The governor and the Senate and the House don't have to do anything, and they don't have to let us know what they did. I think the only time they have any responsibilities in that regard is if it's a sitting member of the House or Senate and they form a committee. I think they have some notice responsibilities. But with respect to all the rest of this, it's a recommendation. We ask them to let us know so that we can check our boxes, but they're not required to respond and they're not required to do anything. When we've made the recommendation, essentially our work is done. I understand the frustration because you do all this work, you kind of want to see something happen, but that's the way the law is written. With respect to legislative issues, and Commissioners Carson and Cox can probably fill you in more on this, we had a senator who was interested in a couple of our issues. He was from Miami. I heard from him and his staff, but I have recontacted them. I gave them some time after the hurricanes, recontacted them, and I've heard nothing from them. They'll come out of bill drafting. I spoke with Senator Perry, who is the chair of Senate Ethics and Elections. He was, we went through all of our programs. His staff was there, as well as Senate E&E staff. He was quite noncommittal about there being a committee bill coming out with respect to ethics. I will say the Senate E&E committee meeting for next week has been canceled, as has the House Public Integrity and Ethics Committee meeting. So I am not seeing anything moving there. Commissioner Cox and I met with locally City Commissioner Gil Ziffer. He is the president of the League of Cities, and it was significant to meet with him because, of course, our proposal on municipal governing board members filing Form 6 has historically been opposed by the League. So we wanted to see if we could engender some support from him, or maybe, because if they don't oppose it, I think it might have a much better chance. So he was personally not opposed to the idea, but of course, he does not speak for the entire League. But I think that was a positive meeting. I'm sure Commissioner Cox might have something to add. Other than that, I don't have anything to add except that we agreed to set the next meeting of the Legislative Committee at this meeting, so I hope everybody brought their calendars so that we could set that. I had proposed October 30th, but given that there aren't going to be any committee meetings that we're involved in next week, maybe November 6th might be a better day.
And it only applies to the two
Commissioners
people on
Carson
the
and
legislative
Cox.
committees, so we'll let you two decide.
I just wanted to set it today so we can go ahead and notice it rather than having to do it.
I am out of town on October 30 and on November 6.
Okay.
31st, Halloween. All right.
That's fine with me.
Okay. 9 o'clock, October 31st.
You send out an invite? or-
I will.
Okay.
And unless one of you has anything to add legislative-wise, that's all I have.
Commissioner Cox or Carson, do you have anything you'd like to add?
I do not.
The only thing I'll add is that our executive director and I met with Senate Majority Leader Simpson at his business. Linda drove down, and it's in the county I live in, so we met with him there at his business, and he seemed very supportive of the majority of our initiatives, and he is the one who directed us to Senator Perry and since there's not a lot, we're seeing a lot of activity, I contacted him again yesterday, Senator Simpson, and had a pretty lengthy conversation with him, and he's going to be here in Tallahassee next week, and he asked me to resend him the information. I did that, and he said that he would try to get some movement for us on some of those things. So I felt pretty encouraged after the meeting, or after the conversation with him, that we may get a little traction on some of these things. So we'll see how Mayor Pro Tem Ziffer, he said he would follow up with us as to the league's position on that as well. And it was encouraging meeting with him because even though he's a Form 1 filer personally, he actually goes over and above, according to him, goes over and above in listing who his clients are, his tenants. So he does a lot of full disclosure because he doesn't want any appearance. So I think we have a supporter in him personally, but we'll see how the league represents on the thing totally. So
Thanks
that's all
to
I have.
both of you for serving in that additional volunteer capacity. Any other comments for the good of the order? If not, is there any objection to adjourning? Seeing none, we stand adjourned. We will reconvene at 11:35 for the executive session. Thank you.